Good afternoon, everyone. My name is Jason Sitzma, and I'm from the law firm of Shuttleworth and Ingersoll in Cedar Rapids. I'm also the chair of the Intellectual Property Law section of the ISBA and your moderator for today's webinar. I'm pleased that we have joining us today Christine LeBron-Dykeman of the law firm McKee, Voorhees & Cease in Des Moines. Christine is the head of MVS's trademark department. She specializes in national and international trademark protection and intellectual property litigation. Christine has litigated trademark and trade dress infringement, patent infringement, unfair competition, counterfeiting, and cyber squatting cases before state and federal district court and has successfully argued appeals before the federal, 7th, and 9th Circuit Courts of Appeals. She has also managed U.S. and foreign oppositions and cancellations and domain name disputes. Christine's cases have included litigation of trademarks and trade dress in the field of food and beverage, personal care products, arts and entertainment, banking, medical, industrial, consumer electronics and software, and patents directed to seed genetics, agricultural devices, and natural health products. Today, Christine will be providing us with a trademark law update, including a pending Supreme Court case, appellate cases, and the new rules for the Trademark Trial and Appeals Board. Before turning it over to Christine, I want to remind everybody that if you have any questions during the webinar, you can please send them to me using the chat feature on your pop-up. And with that, I will turn it over to Christine.
Good afternoon, everybody. Like Jason indicated, I wanted to just go through a few things of some of the interesting developments, I think, in the trademark world over the past 12 months or so. The first thing I wanted to talk with you all about, and the thing that I think is most likely at the forefront of everybody's mind, is the case that was just granted certiorari by the Supreme Court in late September of this year, and which will be heard in the October term. They haven't yet set a hearing date on it, but we will soon be able to hear the arguments in the Lee v. Tam case. This case, for those who are unaware, is a case that's set to answer the question of whether disparagement provision, the disparagement provision of the Lanham Act and 15 U.S.C. 1052A is facially invalid under the First Amendment free speech clause. And as with so many cases that end up before the Supreme Court, there is currently a circuit split with respect to this issue. So I'll talk to you about the Lee v. Tam case and where that is, and then I'll talk to you about and how that came down at the Federal Circuit, and then we'll talk a little bit about the Fourth Circuit and the case that was there, and a case that was not accepted by the Supreme Court. But starting with Lee v. Tam. So this case originated back in 2011 when Simon Tam filed a use-based trademark application for the mark The Slants for his musical band. He had based the application on use dating back to 2006, but the application was filed in 2011. And this application was immediately rejected by the PTO under 1052A, or Section 2A, on the basis of the fact that the mark was disparaging. And so when the PTO looked at this and looked at, under Section 2A, trademarks may be or shall be refused registration on account of, or I can't read my own printout because it's blocked by something, but essentially trademarks may be refused registration if they consist of matter which may disparage persons living or dead, institutions, beliefs, national symbols, etc., or will bring them into contempt or disrepute. So the Trademark Office looked at this Slants trademark and evaluated it by virtue of looking at some information. Essentially, the Trademark Office found itself the evidence that it was relying on was things like dictionary definitions. They had a number of those that indicated that the term, the slants or slant eyes, were derogatory terms for Asian Americans. They also looked at a publication from the Japanese American Citizens League on hate speech, where the league identified slant as derogatory, and then they in fact included a number of news articles relating to the slants ban itself, where it had been noted that this was a derogatory term. People had actually canceled concerts as a result after learning what the name was, etc. And there was also some information that the slants identified that they had in fact, adopted the name specifically because they wanted to sort of take back that terminology. So Mr. Tam was unable to overcome the rejection. He appealed to the TTAB, and the TTAB affirmed the PTO's decision back in 2012, and then the case got appealed to the Federal Circuit. Initially, the case went before a 3-judge panel, and the 3-judge panel likewise affirmed the board's decision. On appeal, the argument by Tam was essentially that the denial violated his First Amendment rights of free speech. Following that, Tam sought en banc review, and the entire Federal Circuit took this up. And although there was a split decision, the majority in this case reversed the earlier decisions and found that the mark is registrable. Essentially, the majority applied a strict scrutiny analysis and held that disparagement, the disparagement provision of Section 2A improperly violated a fundamental constitutional right of speech based on impermissible views-based or content-based information. So basically, the Trademark Office is imposing its views on whether this is derogatory or not, and by virtue of that, it was impermissible. Judge Moore, writing for the majority, held that heightened scrutiny was the appropriate scrutiny to look at when reviewing this case, because whenever the government creates a regulation of speech because of disparagement, then it becomes government speech, and there should be reviewed under the strict scrutiny analysis. The Federal Circuit majority explicitly rejected the government's argument that by virtue of being commercial, that because the Section 2A regulates commercial speech, not government speech, that the standard of review should have been intermediate scrutiny as opposed to strict scrutiny. However, according to the majority, the PTO's processing of trademark registrations no more transforms private speech into government speech than when a government issues permits for street parades, copyright registration, certificates, or for that matter, grants medical, hunting, fishing, or driver licenses, or records property titles, birth certificates, or articles of incorporation. And so the court held that it was not commercial speech, but rather it was government speech and entitled to the stricter review. The court noted, however, that even if an intermediate scrutiny test were used, that Section 2A would still be unconstitutional. So it went through that analysis just to presumptively avoid, having a reversal just based on the higher scrutiny analysis. And it looked at the intermediate scrutiny test that was derived from a 1980 Supreme Court case in Central Hudson v. Public Service Commission, and analyzed first whether the activity was lawful and not misleading, and then assessed whether the government's interests were substantial and narrowly tailored to achieve those government interests. Applying that, the court said that this was not information that was unlawful or misleading, and so therefore essentially said that even under the intermediate scrutiny test, it would be found to be unconstitutional. Lee, Lee, who is the director of the PTO, filed for cert in April of 2016, and cert was granted September 29th. The oral argument on this is not yet set. On the flip side, you have the case of Pro Football v. Black Horse. And Pro Football v. Black Horse, which is a case currently pending actually at the Fourth Circuit, actually hasn't even been heard by the Fourth Circuit as of yet, but it is a case that actually started many years prior to the Slants case. This specific case, Pro Football Inc. v. Black Horse, which was at the time Black Horse v. Pro Football Inc., was a cancellation proceeding filed in 2006 by Black Horse and other members of the Navajo Nation against 6 Redskins formative marks, or marks that are owned by the Washington Redskins and shown up on the screen here. That case actually dated back even further to a 1999 Hirschfeld v. Pro Football case, which had been filed as a cancellation proceeding at the trademark office on the same exact 6 marks. So back in 1999, in the Hirschfeld case, the case was filed. The allegations were that the marks were derogatory or scandalous, and Hirschfeld sought for those marks to be canceled at that time. These marks, mind you, have been in existence and been used by the Washington Redskins for nearly 50 years at the time of the filing. That case, the original, the Hirschfeld case, the trademark office canceled the marks, and then it went on appeal to district court and up through the D.C. Circuit and into the up through the D.C. Circuit, I believe. No, sorry, the district court in a district court in the, I think it was District Court of Virginia, my apologies. And that case eventually back and forth through the district court, the TTAB, and the circuit court was actually eventually dismissed not on the substantive issues but on the issue of latches. In essence, the petitioners in that case had all been around and alive long enough that, or age of majority long enough that the court found that they should have brought the case earlier than they did. So ultimately, the case was dismissed, but it didn't really change the issue of whether these marks are disparaging or not. So in the interim, while that case was pending before it was finally ultimately reversed in 2009, the Black Horse group went ahead and filed another case, presumptively just anticipating what the result was going to be there on the latches issue, and they filed a cancellation for the same 6 marks. In the Black Horse case, the TTAB again canceled the marks on the basis of disparagement. Interestingly, I think the parties in both cases, the Black Horse case and the Hirschfeld case, both times they filed cancellations both because the marks were scandalous and because of disparagement. However, in both instances, the courts really went down the line, or the TTAB went down the line of disparagement and sort of ignored the scandalous mark issue. And in that note, just to keep in mind, on a trademark sense, disparagement and scandalous are reviewed a little bit differently by the trademark office because of the parties that you're looking to. So when the court is, or the TTAB or any court is evaluating the issues of disparagement, there's a 2-step inquiry to it. What is the meaning of the matter that's in question? So looking at the Black Horse case, what is the meaning of the Redskins terminology or the designs that are in those logos? And then is that meaning disparaging to a substantial composite of the referenced group, here Native Americans? So the court, when you're looking at a disparagement issue and you're targeting it solely to the group that's being targeted in that wording of the mark or the looks of the mark. On the other hand, when you're looking and evaluating for scandalous marks, the TTAB is looking essentially at the same 2-part test, but instead of looking to any specific group, they're making the analysis as whether it would be scandalous to a substantial composite of the entire public, the general public. So it's a much different analysis. And in both the Hirschfeld case and the Black Horse case, the TTAB just went down the line of looking at it from the disparagement issue with respect to the petitioners that were bringing the case and whether or not these were disparaging to Native Americans. The Black Horse case then went up on appeal as well, and in that case, the Fourth Circuit was taking the review. Pro Football filed its appeal seeking a review on 3 different reasons. The first reason with respect to whether disparagement violated the First Amendment, free speech rights. Second, whether disparagement as used in the statute is too vague and therefore unconstitutional on its face. And then third, in this case, they were also raising the issue of the fact that when you have a mark that isn't canceled for, that exists on the registry for over 50 years, is there a problem for due process rights issue in the cancellation that far down the line, especially when you lose evidence and witnesses that could testify in the case. So there was 3 issues that were in the Pro Football case. The Federal Circuit, the Fourth Circuit, my apologies on these, scratch that, sorry. The Eastern District of Virginia, which is the case, it went from the TTAB to the Eastern District of Virginia. In the Eastern District of Virginia, there was a summary judgment motion that was filed by Pro Football on all 3 of those issues, and the Eastern District of Virginia, unlike the Federal Circuit in the Slants case, held that the statute, Section 2A of the Lanham Act, is entirely valid and constitutional. Looking at it, the district court denied the motion for summary judgment because for 2 bases with respect to the First Amendment issue. First, the Lanham Act does not implicate the First Amendment because no conduct is prescribed and no tangible form of expression is suppressed. And the reasoning behind that is the Section 2A only relates to the ability for a mark to be registered or not registered. It doesn't in any way impact the ability of a trademark owner to actually use that mark in commerce. So the Eastern District of Virginia looked at this and said the court is, or the TTAB isn't stopping any use of this mark at all. Rather, it's only stopping government approval of it on the trademark registry. And second, the District Court of Virginia held that the government speech, or the trademark registration program relates to government speech, and then in their minds it was exempt from First Amendment scrutiny at all. The Pro Football had filed an appeal with the Fourth Circuit, and that appeal is pending. During the pendency of that, but before the briefs were filed and any argument was heard, the Slants case, Mr. Tam sought certiorari, Ms. Lee sought certiorari from the Supreme Court to take up that case there. So 5 days after the petition for cert was filed in the Lee v. Tam case, the Pro Football filed a petition for cert at the Supreme Court as well, and essentially made the argument that either this is a great companion case and the court should take them up because the same issues arise in both of these cases, or alternatively, and somewhat emphatically, they argued that in this case, the Pro Football case should actually be the one the court takes up because it involves this issue of First Amendment rights, but it also addresses the vagueness issue and due process issue for marks that have existed on the trademark registry for such a long period of time. The cert was denied for the Pro Football case on October 5th of this year, so just days after certiorari was granted in the Slants case. What's interesting is this law of the disparaging marks has existed since the Lanham Act came into being in 1946, but this will be the first time that the Supreme Court is addressing this. So up until now, the Trademark Office has had pretty much carte blanche to decide what it believed to be disparaging, scandalous, immoral, etc. So it'll be interesting to see where they come down on this after oral arguments in this case. There's a lot of talk out there about why it is that the court took up the slants case rather than the Redskins case, and there's some question as to whether or not they took it up just by virtue of the fact that the Federal Circuit in slants has invalidated the statute and therefore they need to address it at this time, or whether it's because the slants case was filed by a petitioner, by the director of the PTO, and the court generally takes up cases more readily when they're filed by government entities. In any event, it is going to lead, this issue will certainly have a substantial impact on a lot of different marks that are out there in existence on the registry right now, and applications that have been filed over the last 60, 70 years. So in that case, we're sort of left to see what the court will do. We know what the circuit split is, and we will see eventually where they come down on it. So just as one more aside on that, certainly there's some value, I think, to the concept that this isn't an impact on speech directly, because as the Eastern District of Virginia noted, you're dealing only with the ability to register a trademark, not the ability to actually use that. But that has to be juxtaposed to the fact that there are substantial benefits that are gained by having federal registration, which is why we all encourage our clients to file for registration, and it is those rights that are being prevented by virtue of not being able to register these marks. So it'll be interesting to see where the court comes down in the end on this one, but it'll be heard in this session sometime. The next topic that I wanted to bring up, and the next thing that is, I think, of sort of high impact, is relating to the nominative fair use doctrine. And currently there is a petition for cert that was just recently filed in the Supreme Court on this issue as well. Ironically, we'll be talking a little bit about bans again. Talked about the slants, and next we'll be talking with a little bit of history about New Kids on the Block back a few years back. So, excuse me. So with respect to, we all know what descriptive fair use is, and descriptive fair use is when a term that is a trademark is used descriptively by someone else to describe their own goods. Something simple, you can take an example of the police is a trademark, and yet, of course, in describing the police in any area, you need to use the terminology the police. Descriptive fair use has been codified in the Lanham Act in Section 1115b4 since 1946. Nominative fair use is something that is not codified in the Lanham Act, and the doctrine arose about 24 years ago in the Ninth Circuit in a case called New Kids on the Block versus News America Publishing. And in that case, the facts very simply were that the newspaper had conducted a poll that sought to determine the hottest member of the New Kids on the Block band. Judge Kaczynski of the Ninth Circuit, who authored that opinion, arrived at I'd say, relatively simple three-part test to determine if the use by the newspaper entity of the New Kids mark was excusable fair use by looking at three different factors. First, do you need to use that mark to refer to the plaintiff? Second, is no more of the mark used than is necessary? by virtue of that, it's generally, if marks have logos, are you just using the word mark and not also utilizing the logo in order to do that? And then third, are you doing nothing to suggest that there's sponsorship or endorsement by the trademark owner? If you need to use the mark to refer to them, you're only using as much as necessary, and you don't do anything to suggest any sponsorship or endorsement, then the Ninth Circuit held that would be nominative fair use. I'm going to jump here for some reason. Something's out of. So in this case, so since 1992, several circuits have recognized some existence of a nominative fair use doctrine. Following the Ninth Circuit is the only one that uses the nominative fair use doctrine, the three-step test, essentially to replace a likelihood of confusion test in any trademark infringement claim. So if someone brings a trademark infringement claim and the defendant is asserting as a defense that there's nominative fair use, the Ninth Circuit under New Kids decided that that question would be answered first. If there was nominative fair use, there's no reason to even look at the issue of likelihood of confusion. And in fact, the Ninth Circuit held that when there is a nominative fair use defense asserted, that the burden of the proof is on the plaintiff to show that it was not nominative fair use. So that's the Ninth Circuit's nominative fair use doctrine. Following that, and in the intervening years, there's been a variety. If you look at this chart that's up on the screen, there's been a variety of sort of modifications or differences based on that. And so you have different circuits. You have the Third Circuit and the Fourth Circuit who buy into the notion that nominative fair use can be a defense, but they hold that it must be an affirmative defense. So the burden of proof is on the defendant to prove that three-part test, essentially, and to prove that their use was nominative fair use. Then you have the Fifth Circuit that essentially has incorporated the two of the factors from the Ninth Circuit's test into their likelihood of confusion analysis. So they make it part and parcel just of the test itself, essentially putting the burden of proof on the plaintiff, but also looking at all the other confusion factors and sort of making it just a balancing amongst those. So I think it certainly has less significance there. In the First Circuit, the court has held, well, you don't even get to the issue of nominative fair use until after you have looked at a likelihood of confusion and determined whether or not confusion exists. So in all of those circuits, there is certainly some recognition that there should be and is a nominative fair use doctrine that is applicable, that there are certainly times when it's appropriate for someone to use somebody else's trademark in commercial usage, any type of commercial usage. It happens a lot in sort of advertising, comparative advertising, and the like. Certain circuits, however, the Sixth Circuit, I should say, one circuit has actually held that they do not have any nominative fair use doctrine at all applicable, and so they just don't see that as any sort of defense to trademark infringement. And then, of course, you have the 7th, 8th, 10th, 11th circuits, the District of Columbia, and the Federal Circuit. None of those circuits have addressed this at all, which leaves a bunch of district courts in those circuits deciding amongst the other circuits analysis and making, pulling from one circuit or another, or making up their own analysis with respect to this. So this case has now come up again because it's come up in the Second Circuit right now, and this is in the International Information Systems Security Certification Consortium, originally the Security University LLC. And in this case, the consortium developed a certification program for information security, for the information security industry, and owns a certification mark, CISSP. The defendants were certified through that consortium, and initially were using the mark appropriately as they would normally do, just saying that they are CISSP certified. Eventually, however, Security University decided to develop its own classes and teach some information security training themselves. So they began running ads like the one up on the screen that advertised a master CISSP, or that you could become a master CISSP. Somewhat they were using master descriptively, but in some ways you can see that they were trying to use it certainly in a trademark sense by virtue of having the master in capital as well as the CISSP. And then, of course, you know, for example, up here they utilized the R in a circle afterwards. The consortium the consortium sued under the Lanham Act for violation of their certification mark, indicating that they thought that this was not, this was likely to be confused with the CISSP mark. They filed under 1114, 1125A, dilution, etc. And the defendants in the case turned around and asserted that there was nominative fair use of the mark, and so they should be allowed to use it. The district court granted summary judgment to the defendants, finding nominative fair use and no likelihood of confusion. Effectively, they followed the Ninth Circuit and said that they found that there was nominative fair use, and that following that, they also did look at all of the likelihood of confusion factors. So again, they came up with some sort of a hybrid between the different ways of looking at nominative fair use. So the Second Circuit, in looking at this, indicated that they came up with this sort of mesh again, and said, you look at this with respect to the Second Circuit altered the district court's opinion and held that essentially they looked at the Ninth Circuit factors, but they made some variations on those factors. They combined them with their traditional Polaroid factors, which is the Second Circuit's likelihood of confusion factors, meshed it all together and came up with an analysis there. And so they ended up reversing the grant of summary judgment and sending it back down to the district court. Security University filed a petition for certiorari on September 15th of this year, and the INTA, International Trademark Association, has recently filed an amicus brief on this, going back and pointing out to the court all the differences in the different variations of this analysis of within the different circuits, and emphasizing that, of course, this just encourages forum shopping and causes lots of problems for defendants around the country on trying to figure out where cases are and how they can get moved to a district that might have a better view on this for them. So again, I don't know whether or not the Supreme Court will take this up. It does, in my mind, seem like it is something that should be taken up by them, because there is such a vast way of looking at this issue around the country. So those are, I'm going to say, sort of the exciting trademark cases that have either one that has been taken up on cert and one that the petition is pending. In some other less exciting news, but things that have happened in the trademark cases that I think are certainly good reminders in our practice. So you had recently there's a case of New Millennium Sports v. Jack Wolfskin, which case was the cert was denied in 2015, it might be 2016, but the case in 2015, the Federal Circuit overturned a Trademark Trial and Appeal Board decision finding that two paw print marks that confusingly similar for various clothing articles. The case stemmed from an opposition proceeding filed by New Millennium against Jack Wolfskin. New Millennium owned the Kelm mark in the upper right-hand corner here. That mark, the Kelm with the paw print, was a registration that they had dating back to the early 2000s. Jack Wolfskin had applied for the paw print on the right, and New Millennium challenged that, filed an opposition against that mark, indicating that it was likely to be confused with its Kelm mark. Jack Wolfskin defended against the cancellation on two different bases. One, that the marks were not confusingly similar, and alternatively that New Millennium had actually abandoned its trademark registration in 2004 when it changed from the Kelm mark in the upper left-hand corner to the Kelm mark in the lower left-hand corner of the screen. So the Trademark Office, when they took a look at this, they found no abandonment. They said that the Kelm mark to the Kelm mark were sufficiently similar that they maintained the same commercial impression, and so they held that there was no abandonment. They found, however, that there was likelihood of confusion. And looking at the factors that they evaluated, they found that the vast majority of factors supported New Millennium. The only factor that they looked at as a question as to that was whether the paw print of Jack Wolfskin versus the Kelm paw print of New Millennium were sufficiently similar. And they essentially held that because a lot of clothing manufacturers utilize a design element of a logo separate and apart from their word mark, that was sufficient to find that they were similar in sight, sound, and meaning. Jack Wolfskin had also raised an issue with respect to a number of other paw prints that were out there in existence for clothing, and the Trademark Office essentially found that that factor was not sufficient to overcome the confusion issue. On appeal, the Federal Circuit looked on appeal. The major issue before the Federal Circuit on this, they had the two issues again: the abandonment issue as well as the issue with respect to likelihood of confusion. With respect to the abandonment issue, the Federal Circuit looked to the 2015 Supreme Court decision in Hannah Financial Bank versus Hannah Bank, which held that in the context of a priority dispute, that if the old form of a mark and the new form of a mark are, quote, legal equivalents, i.e. they have non-material alterations, that tacking was permitted for a priority issue. And the Federal Circuit held that that same analysis should apply in the abandonment context, so that if the new mark was substantially equivalent or legal equivalent to the old mark, that abandonment did not exist. Also, following Hannah, the court held that the issue of whether there is a substantial equivalence of these marks and that same continuing commercial impression was a question of fact. So looking at this from that analysis, the court concluded that it had to review the Trademark Trial and Appeal Board's factual determination for substantial evidence, meaning that the court needed to ask whether a reasonable fact finder might find the evidentiary record put before the TTAB sufficient to come to that conclusion. And if that record would be sufficient, then they had to uphold those findings of fact, which they did. And on the likelihood of confusion issue, However, the court reversed the board's finding of likelihood of confusion on the basis that the Federal Circuit held that essentially the statement by the Trademark Office or the TTAB that that the use of a mark, the logo separate from the word mark, was regularly done, was not actually supported by the evidence. That the Trademark Office just didn't provide any evidence to support that. They just made that general conclusory statement. And the court held that that was not supported by the evidence, and therefore that, these marks, from their perspective, you had to review them as they are, and as the mark is registered, that mark has a word mark that is quite distinctive, and so the circuit reversed the board's finding. Wolfskin petitioned for certiorari, but that was denied in January of 2016. Wolfskin offers what I'd say is some minimum hope to trademark owners who inevitably alter their trademark designs over the years. And to this I say minimal hope because this is a question of fact, which means that the fact finder, whether it's the jury, the TTAB, or a judge, it's whether or not they perceive any non-material alteration or any alteration to be a non-material alteration, and whether they perceive that that has the same continuing commercial impression as the original. So all that said, it certainly gives some hope that as clients will inevitably change their designs, we might be able to help them to still maintain the rights that they have in those marks over time, whether as a priority issue, as we know from the Hannah case, or as in an abandonment context in a litigation. However, I still think it's important to advise clients early, very early in the process, that any changes that they make to marks over time may actually affect their rights, because again, we're looking at a fact question down the line. So it could affect their rights at the time of filing a Section 8 declaration, Section 15, or any renewals. It could also affect their rights down the line in any potential litigation. With respect to use in commerce, is another recent Federal Circuit case that was also rejected for cert, denied cert from the Supreme Court, and that is the Couture v. Playdom case. And in that case, you had an individual, David Couture, who owned a registration for the mark Playdom for a long list of educational and entertainment services. When Mr. Couture applied for registration, he utilized a web page, photo of his web page, which had a web page he launched in 2008, and it said, welcome to Playdom Inc. We are proud to offer writing and production services for motion picture, film, television, and new media. Please feel free to contact us if you're interested, and gave some information for contact information. The mark was registered on January 13 of 2009, but although the actual website had been up since 2008, and certainly Mr. Couture was ready to offer services and interested in offering services, he didn't actually render any services until 2010. In February of 2009, Playdom Inc., which is a subsidiary of Walt Disney, filed a trademark application for the mark Playdom, which was of course rejected based on Mr. Couture's Playdom pending application. So, which was ultimately registered, and Playdom Inc.'s mark was therefore finally rejected. Playdom Inc. turned around and sought cancellation of the registration for Couture, arguing that the registration was void ab initio because Mr. Couture had not actually used the mark in connection with the goods and services prior to the filing date of the application. And in some ways, this seems to me like a situation that should have been clear on its face. The statute does indicate that marks must both be advertised and used in connection with the offer, with the services or transportation of services or goods. So there is the statute itself seems to make it clear on its face, but it is something that hasn't been had never previously been addressed by the Federal Circuit specifically. And so when the Federal Circuit looked at this, they indicated we've not previously had occasion to directly address whether the offering of a service without the actual provision of the service is sufficient to constitute use under Section 1127 of the Lanham Act. The interesting thing is that the Federal Circuit in an earlier case had, the ACOC case had stated that, quote, at the very least, in order for an applicant to meet the use requirement, there must be open and notorious public offering of the services to those whom the services are intended. So they previously stated that, but in this case they came down and said, well, that we didn't actually suggest by that statement that open and notorious public offering alone is sufficient to establish use. I would say I'm not sure I think that that language is isn't saying exactly that. But in any event, in May of 2015, Couture petitioned for cert, stating that, essentially arguing that the Federal Circuit's earlier case in ACOC, as well as a Second Circuit case, suggests that the offering of the services is certainly sufficient if the applicant is ready and able to provide them. But cert was denied. What I think this case highlights for anyone who's unclear of this at this point is that there's a substantial importance in choosing the correct basis for a trademark application. Had Couture actually filed this application as intent to use when he filed the application in 2008, instead of filing it as use-based, he would likely have gone through the process, had it approved, and ultimately in 2010 been able to perfect that registration and wouldn't be in this position. So it's just important to remember, it's clear he had that intent to use. He was ready and willing and able to offer those services. So from a practical standpoint, it's just important to remember to look at that and make sure that any clients are actually using the mark in the provision of the services and not just advertising them. The last case I wanted to talk about is the Shammas case, which relates to attorney's fees. And in this case, you had a situation where Shammas filed a federal trademark application for the mark probiotic. The mark was rejected as generic, probably unsurprisingly. He moved ahead and filed an appeal with the Trademark Trial and Appeal Board. The decision of the board of the trademark examiner was affirmed. And it's at this point this case gets a little unique. Rather than appealing to the Federal Circuit, which is the typical way people go about appealing a trademark rejection under 15 U.S.C. 1071A1, Shammas sought review by commencing a civil action in federal district court under 1071B1. Again, perhaps unsurprisingly, he lost on the merits of this, but he was then faced with the fact that the district court required that he pay all of the PTO's attorney's fees and paralegal fees and expenses for this. And the statute relating to this case, the statute under 15 U.S.C. 1071B does indicate that the applicant will pay expenses, but it doesn't make any reference explicitly to attorney's fees. So what's interesting about this case is that there are these two ways to go about filing an appeal from the TTAB, and if you take the one that goes down the route of going to the district court, that district court case held, and then the Federal Circuit affirmed the fact that the trademark, or that the applicant is required to pay the attorney's fees. Mr. Shammas had objected to that, indicating that it was against the American rule of fee shifting, and the Federal Circuit majority opinion said that essentially that this requires much more of the trademark office, because now in these cases there's substantially more work in going to the district court case as opposed to the Federal Circuit, and therefore that this was contemplated and is permissible. The dissent found, held differently and said that it was in contradiction to the American rule. What I think Shammas highlights is the significance of making a very full record at the Patent and Trademark Office when responding to office actions. I guess I should step back and say that the distinction between filing, there's a substantive distinction between filing at the Federal Circuit and filing through the district court. At the Federal Circuit, you are tied to the record that exists before the examiner during the original prosecution, and the evidence is reviewed on this substantial evidence standard. On the flip side, if you go to the district court, it's you get the PTO record, but you can also add additional evidence, testimony, and the like. You can have expert testimony, anything that you want in there that you didn't have before the trademark office, and it's subject to a de novo review. So there are certainly some benefits to going to the district court. However, the detriment is that then you are required to pay for the attorney's fees of the trademark office, and that's regardless of whether you win or lose at the district court. And I think that's significant. It's not even if you lose and waste their time, it's if you win, you've still taken up their time and you're still subject to pay those. So in my mind, what this highlights is just the significance of making a full record at the PTO when responding to office actions. And of course, typically you would have an initial office action, try to make your full record to overcome that so you don't enter the final rejection stage. But even if you get a final rejection, it's important to remember that you can file a motion for reconsideration, which allows you to put in additional evidence before an appeal is filed. Because once you hit that appeal stage, there's no opportunity to add anything further. And importantly, you can file that motion for reconsideration even on the last day, that day of filing the notice of appeal. You can concurrently file your notice of appeal as well as your motion for reconsideration. And in fact, when you file a notice of appeal, it actually has a box to check whether or not you're filing a motion for reconsideration. But you do want to make sure that you have everything you can think of or would need in your record so that you can take advantage of that Federal Circuit appeal route, which of course is certainly less costly. Of course, you still don't get that de novo review, but it's certainly something that gets you probably more than you would otherwise get. The last thing I wanted to talk about briefly was some TTAB rule changes that are going to take place on January 1 of 2017. And there are going to be changes. I think these are, in many ways are making these just much more consistent with the federal rules of civil procedure. So a few that I'm going to highlight here, and then at the bottom you see that there's a website to go to that sort of has a lovely document that has all of the rule changes. But specifically with respect to allowing testimony by affidavit or declaration, as you know, in the testimony period, typically in the trademark office, trademark trial and appeal board proceedings, you actually have to take testimony of your own witnesses. You have to go do a deposition of your witnesses. The new rules allow you to actually take those or to put that testimony in by affidavit or declaration, so long as you recognize that it's still subject to cross-examination. And there's a procedure under the new rules that the opposing party has to give you notice within 20 days of receiving of that affidavit or declaration of whether they intend to cross-examine your witness. And then cross-examination needs to be completed within 30 days of the service, from the date of service of that notice. So there are time limits in there. but it is, I think it's a way to sort of make it economically beneficial to parties in the case. Additionally, with respect to streamlining discovery and pretrial procedures, so currently the Trademark Office, Trademark Trial and Appeal Board has very few limitations on the numbers of document requests for admissions. Under the new rules, these are both limited to 75 instead, just as the interrogatories are at the Trademark Office, so there's a limitation there. Also, a significant change in the rules has to do with the timing. Previously, you could serve your discovery on the last day of the discovery period and have your responses due 30 days out. They have changed that, again, consistent with the federal rules. You have to have your request served in sufficient time for responses to be due on the last day of discovery. Additionally, email service is going to be mandatory for all communications in and between counsel and with the TTAB, and they are actually removing the additional time for filing. You know, previously we had that 5 days added to response periods. There are no additional days anymore. Time to respond stems from the date of service in that. Additionally, they're reverting back to, I think it was like pre-2007 rule that now when you file a new notice of opposition or cancellation proceeding, the board will actually be the one that takes that and serves it on the other side. In a cancellation proceeding, you actually have to now provide some information with respect to the best of your knowledge, the name and address of the respondent. Previously, you didn't need to have that information. There are a number of other rules. One other one I think that's actually significant is this confidential information rule. Under this new rule, the board, if you file documents with the Trademark Trial and Appeal Board, the board may now treat as not confidential any material that it considers cannot reasonably be considered confidential, notwithstanding any agreement or designation between the parties. Doesn't matter what the parties say. If the board thinks it's not confidential, they can deem it so and make it publicly available. So, you know, just a note to be cautious as to what you provide. And then one other minor rule on that, deadlines for responses and replies to motions. So it used to be 15 days, they have upped that to 20. These rules will come into effect in January of 2017, and my understanding is that they will apply to ongoing cases as well as cases filed after that time frame. So these are rules to keep in mind and move forward with. If you want to look at all of them, and there are a lot of small nuanced rules in there, I would send you to that website at the USPTO, and it has reference to all the new rules in there. And I think that's it.